The Revised Standards of Financial Responsibility, an overview. Featuring Arva Thomas, Training Officer, Training and Information Services Group.
Hello, and welcome to this overview presentation on the Revised Standards of Financial Responsibility. So much has happened in the world of Title IV and federal student aid. It's a lot to keep up with. My goal today is for you to have a good, broad-based understanding of the changes related to financial responsibility now that the new regulations have taken effect as of July 1st, 2024. During today's session, I'm going to provide a little background on how we got here. I'll talk about the updated submission deadlines for audits and financials. I'll talk about the updates to the standards for general financial responsibility, the mandatory and discretionary triggers, which is really going to be the bulk of the presentation today. I'll talk about the timeframes for reporting triggering events to ED, how to recover after failing financial responsibility, and then I'll provide some helpful resources. Due to time limits, I will not cover financial responsibility for foreign schools. And because there were no changes made to the methodology behind composite score recalculations, I won't cover that either. Now, it's always good to start at the beginning and provide some context. Before we talk about what has changed in the standards for financial responsibility, let's first define what it is at a very high level. ED considers a school to be financially responsible if it can do three things. It can provide all the services described in its official publications. It can meet all of its financial obligations. And it can provide the administrative services needed to comply with Title IV regulations and requirements. These are the big three. Now, for those of you who were fans of the show This Is Us, then you'll catch that reference. A lot is encompassed within the big three, much more than we could cover in an hour presentation, and most of which is not the focus of this presentation. Instead, we will focus primarily on the regulatory changes related to the meeting all financial obligations part of the definition. Participating schools have access to federal dollars, and ED must have assurances that those federal dollars are not at risk. Why is this so important? I want you to imagine a friend or a loved one who has been attending a school for a while. They've spent time, energy, and money to do so. And one day, they show up at the school and the doors are padlocked. No warning, no idea what happened. The first question, how did this happen? And what do I do now? And why was there nothing in place to prevent this from happening, or at least to make it not so painful for us now that it has? This is why these regulations were implemented. In the past, there were instances when ED's first indication of financial problems wasn't until several months after the trouble occurred, when it was reported in the school's annual compliance audit or audited financial statements. The lag or delay in learning about those issues led to situations where ED learned too late from students, the media, or a state agency that a school had already closed or was facing imminent closure. In those cases, it was too late to secure financial protection that would have mitigated the harm to students and taxpayers. To minimize that risk, ED made regulatory changes that provide a more robust framework for ED to identify schools at financial risk and to be able to do so in a timelier fashion to further protect students and taxpayers from financial harm due to school closures, especially, and also for other reasons. Participating schools that do not meet one or more of the standards of financial responsibility may continue to participate in the Title IV programs by posting a form of financial protection to the department. it is going to be equal to a percentage of the Title IV funds that the school received during its most recently completed award year. That percentage is determined by ED. And depending on the percentage of financial protection, schools may also be placed on provisional certification. The three types of financial protection include letter of credit, cash in escrow, and administrative offset. Institutions may obtain an irrevocable letter of credit, or LOC, from a bank or other financial institution in the amount specified by ED and payable to ED if certain conditions are met. Schools may opt to avoid bank fees that are associated with LOCs and instead provide cash to be held in escrow, and ED can draw upon that escrow account if certain conditions are met. Another option is for schools to fund an escrow account through administrative offset. This method requires the school to be placed on HCM2 and redirects Title IV funds that the school has earned into an escrow account that is held by ED. Once the escrow is funded, the school will be reviewed for release from HCM2. ED may use these instruments in certain circumstances to satisfy debts, liabilities, or reimbursable costs that are owed to the department and that are not otherwise paid directly by the school. Now that we've painted the big picture, let's talk about some of the tools that we use to measure a school's financial responsibility, namely the annual compliance audit and the audited financial statements. The submission deadlines for these have changed in order to align audit submission deadlines for all institutions, regardless of type, and to ensure that audits are submitted to ED shortly after their completion. There's no legitimate reason to delay submitting audits after they have been completed. So it's no longer just the 6 or 9 months after the fiscal year end, depending on the type of school. Schools must annually submit their compliance audits and audited financial statements to ED in a single package. Schools that are not covered by the Single Audit Act, and that would be proprietary schools, you have to do this via the Easy Audit website by the earlier of 6 months after the last day of the school's fiscal year, or 30 days after the later of the date of the auditor's report for the compliance audit and the date of the auditor's report for the audited financial statements. For schools that are subject to the Single Audit Act, and that would be public and private nonprofit schools, this has been the law of the land, so to speak, for many years. Public and private nonprofit schools must submit their audits and financials to ED in a single package to both the Federal Audit Clearinghouse and the Easy Audit websites, and they must do it the earlier of 9 months after the last day of the school's audit period, which would be their fiscal year, or 30 days after receipt of the auditor's report. Now, in practice, FSA will be looking at the date of the auditor's report, just like we do for proprietary schools. Here's an example. Let's say a proprietary school uses the same independent auditor to prepare its compliance audit and audited financial statements together. The school's fiscal year end, or FYE, is December 31st. 6 months after the last day of the school's fiscal year is June 30th. The auditor completes the audit on April 30th, which is the date of the auditor's report. Thanks to this 30-day clause, instead of waiting until June 30th, as in prior years, the school must submit the report by May 30th, which is 30 days after the date of the auditor's report. Now, let's see how things play out if the completion dates for a school's compliance audit and audited financial statements differ. For example, let's say that same proprietary school, for whatever reason, engages 2 separate independent auditors for its compliance audit and audited financial statements. The date of the auditor's report for the compliance audit is March 30th. And the date of the auditor's report for the audited financial statements is April 30th. Thanks to the 30-day clause, we know that the later date of the auditor's reports applies. So, the school must submit both the auditor's report, or rather both auditors' reports, as a single package by May 30th. And that's 30 days after the date of the auditor's report for the school's audited financial statements. The same would also be true if the school used the same auditor for both reports. It is the date of the reports that matters. The new regulations also included another change related to the audits and financials that Ed uses to measure a school's financial responsibility. For fiscal years beginning on or after July 1st, 2024, financial statements submitted to Ed must match the fiscal year end of the entity's annual returns that are filed with the Internal Revenue Service, or IRS. The reasoning behind this is that some of Ed's requirements are based on having 1 or 2 complete years of audited financial statements. And using different fiscal years for departmental and IRS purposes enabled schools to manipulate these timelines. And this happened often enough for Ed to change the regulations to prevent schools from doing so. Requiring the fiscal years to align allows Ed to conduct consistent oversight and relieves the department from having to make case-by-case determinations about a school's financial stability. I should note, though, that this rule is not dictating to institutions which dates they must use. It is just requiring the institutions to be consistent and align the end dates for their fiscal and tax years. We acknowledge that this transition may be complicated, and we address that in the Financial Responsibility Q&A, which is on the OPE guidance website. I have linked to that on this slide, and you want to look at Q&As 1 through 3 in particular. Earlier, we defined the 3 overarching tenets of financial responsibility. Remember the big 3. The updates included in this regulatory package strengthen the benchmarks for meeting financial obligations. Let's look at some updates to the standards for general financial responsibility. Now, you're likely familiar with the general standards of financial responsibility that have been in place for many years and that speak to the meeting financial obligations part of the definition. These include having a composite score of at least 1.5, having sufficient cash reserves to make refunds of unearned title funds, making refunds under your refund policy, repaying Title IV debts and liabilities, not having any mandatory or discretionary triggering events, and not having any past performance violations. All of these are still in place and can be found in the regulations at 34 CFR 668.171B 1 through 4. On July 1st, 2024, Ed updated 668.171B3 with additional general standards focused on meeting financial obligations. These are things that a financially responsible school should be doing anyway, and Ed has simply included them in the regulatory language as requirements. They include paying Title IV credit balances as required under 668.164H2, not being more than 90 days late on payments for undisputed financial obligations, meeting your payroll obligations in accordance with the published payroll schedule, and refraining from borrowing funds from retirement plans or restricted funds without authorization. Now, you heard me mention composite scores in the previous slide as one of the measures of general financial responsibility. Composite scores apply only to proprietary and private nonprofit schools. Ed does not calculate a composite score for public schools. Historically, public schools simply have had to notify Ed of their public status and not be subject to past performance violations. Now we've added additional requirements. First, public schools must not have had a mandatory or discretionary triggering event that Ed deems to have significant adverse effect on the financial health of the school. And secondly, while we used to just require a letter from a government official confirming public status, we now require a signed letter or document from a government official, not only confirming public status, but also confirming the backing of the full faith and credit of the government entity. Ed can request this signed document when the school first becomes certified as a public institution, when the school undergoes a change in ownership to become a public institution, and then simply upon request, such as during the recertification process. Allowing an alternative to a signed letter was a very big issue in negotiations. So schools may submit other signed documentation that meets Ed's approval in lieu of a signed letter. In addition to the general standards of financial responsibility, there are other financial responsibility standards that schools must meet. And there are triggers that signal when a school has failed or may be in jeopardy of failing those standards. In fact, the bulk of the regulatory package on financial responsibility concerns these triggers, both mandatory and discretionary. The triggers are numerous and complex and cannot be covered in depth in this 1-hour session. Instead, we'll briefly describe each one at a very high level. First, we'll look at all of the mandatory triggers that are found in paragraph C of 34 CFR 668.171. These are all situations that might not be reported to the department for over a year until the school submits its annual audits. These triggers are meant to enable Ed to more quickly assess, closer to real time, whether something has happened that threatened the school's financial responsibility, and if so, to be able to secure financial protection before it's too late. There are 11 mandatory triggers. Some have subparts and subtriggers. I'll cover each one at a high level in the coming slides. Some mandatory triggers automatically require a school to provide financial protection to the department. That means that when these triggers occur, no additional evaluation is needed for Ed to determine that the school's financial stability is likely to be adversely affected. 9 of the 11 mandatory triggers automatically require financial protection. Let's take a closer look at each trigger. Legal and administrative actions. This trigger pertains to schools or entities included in the school's prior fiscal year submission of the financial statements. So the schools or the entities that are sued on or after July 1st, 2024 by a federal or state authority for the purpose of imposing an injunction, establishing fines or penalties, or to obtain financial relief such as damages. It also includes schools against whom a qui tam action is brought and in which the United States has intervened. But this trigger is only activated if the federal or state action has been pending for 120 days, or if the qui tam action has been pending for 120 days following the intervention by the U.S. And no motion to dismiss has been filed in that 120 days, or if it was denied. These actions signal to Ed that the school's financial health is in trouble, and we will be proactive in securing financial protection, not only for the students, but also the taxpayers who fund the Title IV programs. Let's move on to GE. This is another mandatory trigger. If 50% or more of the school's revenue comes from failing GE programs in a fiscal year, the school must provide financial protection. This trigger is an indication that the school will lose some or all of its access to Title IV funds after another year of performance results unless it can improve. This obviously would have a significant impact on the overall financial health of the institution, and this is why Ed requires financial protection. Now, I've included a refresher on this slide about what it means for a GE program to be failing, but I will not cover it for the sake of time. You can learn more about GE programs using the regulatory and guidance citations that are included at the bottom of the slide. You can also check out breakout session number 20. Get the information you need on financial value transparency and GE reporting, which will be presented by Dave Musser. The next mandatory trigger is for teach-out plans and agreements where there are financial concerns about the viability of the school. When a teach-out is required for financial reasons, it suggests a risk of school closure and the need to plan for it. This is a red flag, and Ed will require the school to post financial protection. Publicly listed entities. This trigger deals with schools that are owned at least 50% by a publicly listed entity with securities listed on a trading exchange. This would be something like the New York Stock Exchange, NASDAQ, or something similar. If an oversight body that governs the foreign or domestic exchange notes certain compliance issues that are listed here, it will activate this trigger, and Ed will require the school to post financial protection. These include losing access to public markets if the exchange delists the company's stocks, revokes its registration, or takes the company to court, or if the company fails to provide quarterly or annual reports, including considering an extended deadline. These are not common occurrences for large and healthy companies. They are signs of financial stress that do not bode well for the company and in turn affect the school. Remember that as a Title IV participating school, you act as a fiduciary in your administration of the Title IV programs. Ed must protect the integrity of the programs as well as students and taxpayers. 90-10 failure. Now, this used to be a discretionary trigger, and Ed has now made it a mandatory one. 90-10 requires proprietary schools to derive at least 10% of their revenue from non-federal sources in a fiscal year. This means that no more than 90% of their revenue can be from federal education assistance funds, including VA and other sources. So, if schools fail this standard, Ed will automatically require financial protection, and we will keep that financial protection instrument until the school passes 90-10 for 2 consecutive years. Cohort default rates is another trigger that used to be discretionary and is now mandatory. If the school's 2 most recent official cohort default rates are 30% or higher, the school must post financial protection. There are some exceptions to this trigger, though. If the school files an appeal or challenge, or if it requests an adjustment of the cohort default rates for one or both of the fiscal years in question, and that action is either successful, remains pending, or prevents the rates from one or both of those years from resulting in provisional certification or a loss of eligibility, then Ed will not require the school to provide financial protection. The trigger for creditor events applies to schools or entities that have entered into a financial arrangement that includes a stipulation or a clause that says, if Ed takes action against you, you are or you will be subject to default or some other adverse condition on your line of credit, security agreement, or whatever the financial arrangement was. That ed action would be something adverse like HCM 1 or 2, suspension, limitation, or termination. Now, there was some confusion about this trigger and what it means. People thought that ed had to act for the trigger to be activated. That is not the case, and we clarified that in the Financial Responsibility FAQs numbers 21 and 22. The trigger is that the creditor included the language in the agreement. Essentially, the fact that the creditor is worried enough about the institution to include such a condition in the agreement is evidence enough that the department should also be concerned about the institution's financial health and should secure financial protection up front. Financial exigency indicates dire financial circumstances, and it is defined as facing a severe and persistent financial crisis that threatens the school's ability to survive. It's typically a last-ditch effort for schools with big budget deficits to avoid school closure, merger, or drastically reducing their academic portfolio. It may involve ending unprofitable programs and keeping or merging the profitable ones. The school is declaring that it is at risk of being unable to afford its financial obligations. So then, ed requires financial protection. Receivership is another indicator of dire financial circumstances. This is where the court appoints a person or entity to take control of the school's finances to make sure that it pays outstanding amounts that are due to the school's creditors. This is an attempt to avoid bankruptcy because if a school files for bankruptcy, it loses eligibility to participate in the Title IV HGA programs. Again, this is a situation where the school is declaring that it is at risk of not being able to afford all of its financial obligations. And for this reason, ed requires financial protection. So all of the mandatory triggers that we've discussed so far require the school to immediately provide financial protection without any further evaluation from ed. Now let's talk about the mandatory triggers that do require further evaluation in the form of a composite score recalculation before determining if the school is required to post financial protection. So this list is a lot shorter than the list of triggers that require automatic financial protection. There are only 3. And if you are doing the math, you know that I said that there are 11 mandatory triggers, and we just talked about 9 of them. So why are there 3 triggers on this list? Didn't we already talk about legal and administrative actions? Yes, we did, but let's take another look. Legal and administrative actions is one of those triggers that has several sub-triggers. We already discussed one sub-trigger, which was being sued by a federal or state authority or having a qui tam action brought against you where the government intervenes. Here, we are looking at the remaining sub-triggers, all of which require a composite score recalculation before determining if the school is required to provide financial protection. In each of these sub-triggers, the school is subject to legal or administrative actions that have a monetary impact on the school. For example, the school has some legal proceedings going on like a lawsuit, arbitration, settlement, judgment, award, or a determination. So they have that going on, and the school also meets one of the following criteria. The school has a composite score below 1.5, meaning that it is in the zone or failing. Or ed has initiated action against the school to recover funds to pay for the discharges due to approved borrower defense claims. or the school has undergone a change in ownership. In each of these circumstances, ED will recalculate the school's composite score, and if the new score is less than 1.0, meaning that it's failing, the school will have to post financial protection. Withdrawing owner's equity is a potentially destabilizing event. For this trigger, ED looks at two categories of proprietary schools that withdraw equity from the entity. First category is for proprietary schools with a composite score of less than 1.5. The second category is proprietary schools that have undergone a change in ownership, irrespective of their composite score. For the second group, which is the ones that have undergone the change in ownership, ED is looking at owner's equity withdrawals through the end of the first full fiscal year after the CIO occurred. In both cases, if the school's recalculated composite score is less than 1.0, ED will require financial protection. There is an exception, though. Generally, a transfer of equity between entities that are included in the affiliated entity group that was included in the composite score calculation, ED does not consider that to be a withdrawal of owner's equity. Contributions and distributions. This is where a school's financial statements show that an owner put money into the business or made a contribution in the last quarter of the fiscal year and then took it out or made a distribution in the first or second quarter of the next fiscal year. The concern is that the school is manipulating its composite score to hide what might otherwise be a failure. So we assess the effects of these transactions on the school's financial health by recalculating the school's composite score. And if the new composite score is less than 1.0, then we will require financial protection. Now let's move on to discretionary triggers, which are found in paragraph D of 668.171. These are external events or financial circumstances that may not appear in the school's regular financial statements and that are not yet reflected in the school's calculated composite score. Again, the goal for discretionary triggers is for ED to be aware of potential financial issues that could affect a school's overall financial health. And we want to be able to do that sooner, closer to real time, so that ED can take action if necessary to secure financial protection from the school. Now, notice that I said if necessary. Discretionary triggers require a case-by-case evaluation. We will touch on each of the discretionary triggers at a high level over the next several slides. There are 14 discretionary triggers. If ED finds that the event is likely to have a significant adverse effect on the financial condition of the institution, we will require the institution to provide financial protection of not less than 10% of the total Title IV HEA funding for the prior award year, and that is per trigger. So for example, if ED determines that there are 4 triggers that will likely have an adverse effect on the school's financial condition, and these could be discretionary triggers, they could be mandatory triggers, or they could be a mix of both. So 4 triggers. The school will have to provide financial protection in the amount of at least 40% of the total Title IV funding for the prior award year. So 4 triggers and at least 40% means that these triggers stack up cumulatively. Now, the good news is that schools do have the opportunity to make their case to ED regarding the impact these triggering events pose. ED will make the final determination as to whether financial protection is warranted, and we'll talk more about this later in the presentation. Accrediting and government agency actions. This discretionary trigger occurs when a school cannot meet one or more criteria for accreditation, authorization, or eligibility, and the accreditor or government agency places the school on probation or issues a show cause order or similar action, giving the school X amount of time to remedy the issue. If the school does not take appropriate action to resolve the issues in question, the accreditor or the government agency will revoke or remove the school's accreditation or authorization. Ed will evaluate and determine if financial protection is needed in this situation. The full name of this trigger is Other Defaults, Delinquencies, Creditor Events, and Judgments. This is a more robust version of a trigger that existed prior to July 1st, 2024. This essentially concerns institutions that are or may be subject to a default or other adverse action under a financing arrangement. This trigger includes a variety of legal and financial situations where Ed will want to use its discretion to determine if federal funds are at risk and if financial protection is needed. These include when a default, delinquency, or other event occurs that allows the creditor to call the balance due, or to require or impose an increase in collateral, a change in contractual obligations, an increase in interest rates or payments, or other sanctions, penalties, or fees. Or when an institution can be subject to default or other adverse condition as a result of any action by the department. Fluctuations in Title IV volume. This could mean a significant increase or decrease. For example, a significant decrease in Title IV volume could indicate financial problems, like struggling to meet the budget when there is a drastic reduction in cash flow. A significant increase in Title IV volume could indicate rapid growth for which the institution may not have sufficient infrastructure or resources to support the students and deliver the educational services that are promised in their publications. Ed acknowledges that the percentage or dollar amount of a fluctuation will look very different from school to school depending on the size of the institution. So, as with other discretionary triggers, this will involve discussions with the school in order to determine if financial protection is needed. High annual dropout rates. There's no magic number that signifies high. Instead, Ed uses a case-by-case approach to determine whether there are indicators of financial concern. For example, high dropout rates can lead to low enrollment, which could lead to significant financial challenges. It costs a lot to recruit new students, and not having enough students affects the revenue supply. Ed considers these factors as well as the size of the institution and the number of students who drop out to determine if financial protection is warranted. Interim reporting. This trigger concerns schools that have failed financial responsibility standards or that have undergone a change in ownership. This subset of schools must provide additional reporting to Ed when there is a significant change in their financial condition, like negative cash flow or significantly missing cash flow projections that the school submitted to Ed. It could be failing some other financial ratio, or even a significant increase in the school's withdrawal rates. Ed will determine whether the changes warrant posting of financial protection. Now, I mentioned borrower defense in an earlier mandatory trigger under legal and administrative actions for borrower defense claims that have been approved and for which Ed is seeking repayment from the school. But there's also a discretionary trigger that is related to borrower defense. This is when Ed determines that there are signs that a school may have engaged in conduct that merits a borrower defense approval, and then forms a group process to consider the claims that are pending from that school. Depending on the dollar amount associated with the potential claims approvals, this could have a significant adverse effect on the school's financial health. Ed will determine whether to require financial protection. Many schools have the occasion to discontinue a program or close an additional location at some point in time. This is not unusual. And depending on the number of Title IV students that are affected, doing so may or may not be an issue. Ed has now set a threshold for when doing so could be an issue, and that threshold is 25%. Paragraphs 7 and 8 of 668.171D state that if a school discontinues academic programs or closes locations that enroll 25, or rather more than 25% of its enrolled students who receive Title IV HEA program funds, this will trigger a departmental review. The review will determine if these conditions impact the financial status or stability of the institution enough to warrant financial protection. This trigger looks at state actions and citations against schools, up to and including notification that the state will withdraw the school's licensure or authorization if it doesn't take action to resolve the noncompliance. Ed evaluates these on a case-by-case basis to determine if they have or will have an adverse effect on the school's financial health, and if so, will require financial protection. Loss of institutional or program eligibility. This is where the institution or one or more of its programs has lost eligibility to participate in another federal education assistance program. For example, the ones from VA or HHS or another federal agency. And this is due to an administrative action against the institution or its programs. So again, this is something that has happened already. The school lost eligibility or the programs lost eligibility. This trigger is discretionary because its impact could range from minimal to significant. For example, the loss of program eligibility for an educational program with no enrollees or a very small number of enrollees would likely have little or no negative impact on the school's financial condition. But losing eligibility for a program with a considerable number of enrollees could have a major impact on the school's financial health. Ed will evaluate and determine if financial protection is warranted. With this trigger, the institution is cited and faces loss of education assistance funds from another federal agency if it does not comply with the agency's requirements. The difference between this trigger and the loss of institutional or program eligibility one is that here the school has been cited and there is only the possibility of losing education assistance funds. So this is something that might happen, but hasn't happened yet. That could look like the possibility of getting kicked out of an entire program or a portion of a program. So let's say, for example, perhaps the school can still participate in the GI Bill program, but maybe lose something else that is a program for VA. Or the school could possibly have to pay back certain program funds, but is still eligible to receive future program funds. It could look like the possibility of being suspended from participation for a period of time, but being able to return at a later date. It could also look like possible limitations that new enrollees cannot receive funds from said program, but existing enrollees still can. This trigger has a very narrow focus. This is where the entity that owns at least 50% of a school has securities listed on a domestic or foreign exchange, and the entity discloses in a public filing that is under investigation for possible violations of state, federal, or foreign law. This could be cause for financial concern and Ed will determine if financial protection is warranted. Now, you'll recall that I talked about teach-outs due to financial concerns earlier in the section for mandatory triggers. But here, we're talking about teach-outs for other reasons that may still represent a significant negative financial impact. For example, a teach-out agreement required because of concerns about misrepresentation for a program that enrolls half of a school's students may merit financial protection because of the extent of the possible revenue loss. By contrast, a teach-out request for a single small program that's being phased out by the institution would not merit financial protection. And finally, this last discretionary trigger is for any other event or condition that the department learns from the institution or other parties that we determine is likely to have a significant adverse effect on the school's financial condition. Now that we've looked at the updated requirements of general financial responsibility and each of the mandatory and discretionary triggers for financial responsibility, let's talk about when you have to report these events to Ed. And remember, the goal is for Ed to find out about these things as soon as possible in order to mitigate any possible harm to students and taxpayers. 21 days is the magic number for reporting nearly all triggering events. One notable exception is regarding 90/10 failure, which must be reported no later than 45 days after the school's fiscal year end. The clock for the 21 days typically begins when the triggering event occurs. However, there are nuances that would start the clock upon notification from Ed or another oversight entity. Something new and very important is that if the school fails any of the general standards of financial responsibility in paragraph B of 668.171, the school must report that to Ed within 21 days of ceasing to meet the given standard. So, for example, at the point that a school fails to meet its payroll per its payroll schedule, or fails to make refunds under its refund policy, or fails to pay credit balances as required, or any of the other events that are listed in paragraph B, then the school has 21 days to report it to the department. Remember, as I've said, and I'm going to keep saying, the goal is to know sooner and to secure financial protection earlier to mitigate the harm to students and taxpayers. Again, think about your loved one or your friend who showed up at the school and the doors were closed. Now, one more note about the 21 days. Ed issued an electronic announcement. It was General 24-12 on September 17, 2024, which gave schools 21 days from the date of that electronic announcement to report triggers that first began prior to July 1st, 2024, and that were still in effect as of July 1st, 2024. So this means that schools who met that criteria had to report the events to Ed by October 8th, 2024. So I hope that you met that condition. Speaking of Electronic Announcement General-24-112, that same EA also lists information on the types of documentation that schools must provide when notifying Ed about the triggering events that we have discussed today. Do not try to read this slide right now, okay? These next 4 slides are a condensed, unofficial version of what is in the EA. You can read these slides and the EA in their entirety a little later, but I will highlight a couple of examples over each of the next 4 slides. First, let's see what documentation is needed for legal and administrative actions. The school must provide copies of the final judgment, award, or settlement agreement, and proof that the insurance carrier accepts coverage for the full or partial amount of that judgment, settlement, or award. For contributions and distributions, the school must provide a detailed ledger printout of the contributions and distributions made in the last quarter of the prior fiscal year and the first 2 quarters of the current fiscal year, and each time distributions are made in the current fiscal year. There are times when Ed will tell the school just in time what documentation is required if the school activates a trigger. For example, this would be with interim reporting or other events and conditions. And sometimes there is no additional documentation that the school needs to provide because we have already covered the requirements elsewhere in the regulations. 9010 is a good example of this. The regulations at 34 CFR 668.28C4 describe what documentation is needed for 9010 failure. And finally, sometimes no additional documentation is required because the trigger is something that we already know about or we calculate ourselves, like fluctuations in Title IV volume, borrower defense claims, cohort default rates, and things like that. So now we know what to report and when, and what documentation to provide when reporting. Now I want to go back to the statement that I made earlier about schools having the opportunity to make their case to Ed about why they believe that certain events do not impact the school's financial condition to the point of having to post financial protection. The regulations address this in 668.171F3. When a school timely notifies Ed of a triggering event or condition, or in the school's response to Ed's determination that the school is not financially responsible because of a triggering event that doesn't have a notice requirement, the school can include an explanation or documentation for Ed's consideration about why the event or the condition does not warrant posting of financial protection. Specifically, the school can show that the creditor has waived the violation, that the triggering event has been resolved. The school can show that insurance will cover some or all of the obligation for some monetary judgments, awards, and settlements, or other monetary obligations. And the school can also provide other explanations or documentation showing that the triggering event does not, or has not, or will not have an adverse effect on its financial status. Now, if a school fails financial responsibility and has to post financial protection, the next logical question from the school's perspective is, okay, when will Ed release us from financial protection? Let's look at what a school needs to do for Ed to release the financial protection that the school has posted. When a school fails the general standards of financial responsibility, Ed reviews the annual financial statements each year and makes a determination if the financial responsibility issue has been resolved. If it has been resolved, Ed will release the financial protection. Ed can also remove the school from HCM1 if it was due to failing general financial responsibility standards and there is no other reason to remain on HCM1. If the school has a provisional certification, the school will stay on provisional until that provisional certification expires. For all triggering events, the department will consider whether the financial protection can be released after the institution submits 2 full fiscal years of audited financial statements following the department's notice that the posting of financial protection was necessary. In making this determination, the department considers whether the administrative or financial risk that was caused by the event has ceased or been resolved, including full payment of all damages, fines, penalties, liabilities, or other financial relief. We acknowledge that this may be easier said than done, but these are the necessary requirements for Ed to consider releasing the financial protection that the school has provided. And again, remember the reason for requesting the financial protection in the first place: mitigating the financial harm to students in the event of school closure or other financial cataclysm. Think about your loved one again and what you would want to be done for them. And now let's take a look at some helpful resources. These were all mentioned or linked in earlier slides in the presentation, but I've included them here for convenience. If you have questions about the updated standards of financial responsibility, please use the Contact Customer Support form on Partner Connect. Be sure to choose Policy Guidance from the drop-down menu. I want to thank you so much for spending this hour with me as we walked through this mountain of information regarding financial responsibility. I hope that you now have a better understanding of the basics of the updates, and I wish you continued success in administering the Title IV programs.